Well, good afternoon, ladies and gentlemen. It's a great pleasure to be here. I was asked to speak about industrial design protection in the United Kingdom. And one of the reasons I was keen to do so is because I have been involved in a lot of cases involving designs for a large number of years. And there is a view that designs and design protection is very much the Cinderella of intellectual property practice, and that design rights are equally the poor relation of patents and trademarks and indeed copyright. I beg to differ, and one of the reasons for that is that I think in most jurisdictions there are actually very powerful remedies available to protect designs and to protect against infringement. And in many of those jurisdictions, those rights are unregistered rights, which exist provided certain qualifications are observed. And the United Kingdom is no exception to that. I understand India is no exception to that, and various other countries as well. And indeed, when the European Union chose to introduce a design regulation, we'll hear more about that in a little while, they introduced a twofold method of protection, including a longer registered community design and a somewhat shorter unregistered right. But again, the emphasis on unregistered rights. The registration of designs in the United Kingdom has a long genesis and has really travelled along two different tracks. Firstly, the concept of registered rights, which have existed since at least 1907, and unregistered rights, which were based very much upon concepts of copyright. And until 1989, copyright provided the key remedy on the basis of a fiction that design drawings, two-dimensional drawings for an article, could be infringed three-dimensionally. So you had claims for copyright infringement based upon the original design drawings of the claimant, which it would be said were infringed by a three-dimensional infringement, the creation of an article to the design of the two-dimensional drawing. And so copyright cases in those days were very much based upon the design drawings, and you would need a lot of evidence as to the existence of the drawings, the creation of the drawings, whether they're original works for the purposes of copyright protection, and so on. Now, due to a quirk in the law, and I won't go into the detail of the matter, if you had a design which was a functional design, i.e. it lacked any form of eye appeal or aesthetic merit, it had the full term of copyright protection. And I always like to think of the example of perhaps a car, Model T Ford, or something similar, which was designed, let us say, in 1930 by a designer who was age 30. He went on to live until he was 80 in 1980. In those days, the copyright term was 50 years plus life. So the term of protection would continue for another 50 years from 1980 until 2030. So you would have a century of copyright protection for the design of that vehicle, which was obviously rather bizarre. The other issue which was of importance, and still is importance at that time, which gave rise to reforms, was the issue of spare parts. And there was a celebrated case involving spare motor parts. It involved exhaust pipes in a case called British Leyland and Armstrong in 1986, in which British Leyland, a car manufacturer, sued for design copyright infringement in the design of an exhaust pipe. And the House of Lords, the United Kingdom Supreme Court, tried desperately to avoid a result which would prevent the public having the inability they found in that case for the defendant, and held that the consumer had a right to have spare parts manufactured. Now, that was a very unsatisfactory state of affairs, and in 1988, a new Copyright Act came into play, and I'll speak further about the copyright issues, but essentially it introduced two new rights. It extended the existing registered right for another 10 years, from a maximum period of protection of 15 years to a period of 25 years, and introduced a new right called Unregistered Design right, which I'll talk about in a moment, which is actually a very powerful right and has been interpreted on quite a restrictive basis. So moving on to the slides, if I can make this work. Can I just have some help in moving this? Just show me which key to use, please, to get on to the next slide. It's that one. Thank you. So the relevant law that we have to look at is both UK and EU law. The Registered Designs Act 1949, which gives the 25-year period of protection for registered designs which qualify. The Copyright Designs and Patents Act 1988, which limited copyright protection and introduced the unregistered right. Then the much more recent EU directive on registered design harmonization, and the EU regulations on community designs, which introduced the EU registered design right, the community design right, and the community unregistered design right, which I will talk about in a little while. There's also, of, I think, considerable relevance, the Copyright Directive, because it may well be that the United Kingdom has got it wrong and is acting unlawfully in relation to EU law, in relation to the copyright protection of designs. And I'll come on to that in a moment, because it's an interesting subject. So that's the scheme of protection. There is one other subject, and I'm not going to touch upon that, because I think it's going to, I think Guillaume is going to deal with the issue of trademark and design interchange, so I won't bother about that. But trademarks are there in the background. One of the leading cases in English law involved the Coca-Cola bottle. So to give you an indication what we're talking about, the very distinctive design of the Coca-Cola bottle, whether or not that was subject to trademark protection. Under the old trademark law in the UK, it was held that it was not capable of protection as a trademark. And the new post-1994 European trademark law, as it applies in the UK, I think the design of the Coca-Cola bottle would undoubtedly be registrable. But that's the sort of subject matter for trademark law, and I'm sure Guillaume will deal with it in a way which is far better than I could. UK registered designs. There's a definition of a design. The design essentially is features of shape and configuration of the design. The design must be novel. So in design infringement actions, one is constantly looking, if you're acting for the defendant, to declare the design invalid on the basis that it's anticipated, that it's not novel. The design must have individual character. It cannot be a design dictated by technical functions. Now, what do we mean by technical function? Let me give you an extreme example. The leading case is called AMP and Utilux, and it involved an application for the design protection of a terminal block in a washing machine. Now, the sole purpose, it's interesting I use the word purpose, of that terminal block was to connect two pieces of wiring to make an electrical contact. Nobody cared what the block looked like. It had to work. There was no aesthetic feeling. Against that, you have most consumer articles, and people do care what they look like. ranging from clothing, the outer design of electronic goods, furniture, anything that you can buy in a supermarket, packaging. It's designed to appeal to the eye so that people purchase based upon the design. Now, the problem arises, or arose, when you had designs which fell astride both. And I can just think of a couple of examples. One is Concorde. Remember the supersonic aircraft? Nobody really cared what Concorde looked like, but it was a rather beautiful shaped plane. It was solely dictated by its technical function. Nobody cared whether it was a beautiful plane. It was incidental that it was a beautiful plane. And there are other examples. A propeller for a ship. I'm sure you've all seen mounted in yacht clubs beautiful propellers made out of bronze. They're a lovely shape often. But again, their sole purpose is to move a ship along at the highest speed. So they're dictated solely by the technical function, and it's irrelevant that they happen to have an aesthetic element as well. Now, infringement of registered design is essentially that it's the same as the design of the registered design. The way it's dealt with, and actually European law is incorporated into UK law for this purpose, and I'll just quote Article 10 of the Community Design Regulation. The scope of the protection shall include any design which does not produce on the informed user a different overall impression. So if it produces the same overall impression, you have an infringement. The other thing to bear in mind is that it's a monopoly right, and it is not dependent upon copying. And this came up recently in the English proceedings in the Apple and Samsung case. And I just quote from the judgment of retired appeal court judge Robin Jacob, who sat on the appeal. He said this: because this case and parallel cases in other countries has generated much publicity, it will avoid confusion to say what this case is about and not about. It is not about whether Samsung copied Apple's iPad. Infringement of a registered design does not involve any question of whether there was copying. The issue is simply whether the accused design is too close to the registered design according to the test laid down in the law. Whether or not Apple could have sued in England and Wales for copying is utterly irrelevant to this case. If they could, they did not. Likewise, there is no issue about infringement of any patent for an invention. So that says it all. I'm going to move on to talk about UK unregistered design right. And there's an interesting table which is in the paper setting out the distinctions. So a registered design has to have an examination at the designs registry to show that it is novel, whereas unregistered design right, it rises automatically, subject to qualification. The unregistered design right needn't be novel, but it has to be original. It must be created independently and not be commonplace in the design field in question. Now, it's interesting because in registered designs you have a patent concept of novelty. In unregistered design right you have what is essentially a copyright concept of originality. Infringement of an unregistered design right requires copying. The defendant must have copied. There must have been an act of copying. Whereas, as I've just outlined, the registered design does not require copying. The registered design has a maximum term of 25 years, whereas the unregistered design right has a maximum term of 15 years. And you can have the two rights coexisting together. Definitional design, again, really features of shape and configuration. Originality, it must be original in the design field in question. And there's scope for a lot of evidence from industrial designers to look at the design and express a view as to whether it is original, whether looking at the state of the art, the design field in question, whether or not that design is original. Infringement, again, very straightforward. You just balance the two designs and see whether the features of the earlier one have been taken by the alleged infringement. There is an interesting development. There was a case called Totes and Fulton and another case called Ocular Sciences, in which the English courts interpreted this by saying you could actually take individual features of the overall design and say that those individual features attracted a separate unregistered design right protection in addition to the overall features of the design. So you could have, let's say, a teapot, design of a distinctive teapot. You can have separate unregistered design right in the handle, in the lid, in the body, in the spout. And you have a separate unregistered design right in the overall design of the teapot as well, which is quite powerful from the point of view of claimants. And also, it may well be until the case is actually pleaded against you, you don't really know what aspect of the design is pleaded against you. I talked about spare parts. British Leyland, introduced into unregistered design right law, was a must-fit, must-match exception, so that if the design has to fit with another design, for example, a car part, the door of a car has to fit with the rest of the body of the car, and the design is designed so as to fit, then it doesn't have a separate design right protection. There's also a separate must-match exception, and again, car parts have been trotted out as an example of that. There is quite a strict qualification for design right, unregistered design right infringement in England, and it's essentially this. You can qualify if the designer of the design is either a UK citizen or an EU citizen, or the design was first marketed in the United Kingdom or a EU country, or the design was created by a citizen of a number of designated countries. And those designated countries, apart from the EU countries, they're largely the British colonies, places like Gibraltar and the Falkland Islands, and the only country of any significance in that list, which has been separately designated, is New Zealand. And the countries of the European Economic Area don't apply for this purpose. So Norway and Switzerland, if the designs are created by a designer who's a citizen of Switzerland or a citizen of Norway, does not have entitlement to unregistered design right, whereas an EU citizen, say a citizen of France or Malta, would qualify. So it's a bit odd and restrictive. And it's been much criticised, for example, not giving protection to, say, designs created in India, Japan, United States, and so on. And I think it's a significant failing in the legislation. Why should there be this restriction? The original reason why it was limited was that the British government felt that there should be reciprocity, that it would only give protection to other countries which had similar protection. But I'm not sure that holds water. EU unregistered design right. This is largely a temporary right. It lasts for 3 years, and it's designed to enable a longer registered EU right to come in.